Yes, Mr. Welsh.
My Lords, I appear for the appellant WildFish. My own friends Mr. Streeton and Miss Bruce Smith appear for the first respondents, and Mr. Mohammed and Mr. Abedian for the second respondents. You will have seen the third respondents have not taken part in the proceedings.
Yes.
In addition to the core supplementary and authorities bundles, which I hope have made their way to the court, there are some further documents that were sent in recent days. The first of those,
got some documents yesterday.
There were some yesterday and some on Monday. On Monday, a clip of documents at the request of the court, comprising application forms and cover letters. Yesterday, the Whitley case, section 56 of the planning infrastructure. 25.
Yeah.
Grateful for that. This is an appeal against a judgment of Mrs. Justice Lang to dismiss a judicial review in relation to grant of reserved matters approved on the discharge of conditions. Group my submissions under 5 issues. 3 relate to ground 1 of the appeal and 2 relate to the second ground of the appeal. The first 3 are the interpretation of the outline planning permission. Secondly, the assessment of the facts and assessment of the facts of the reserved matters approval application. Thirdly, asking the inver-Clyde question whether there was a substantial alteration to the live application. And then under ground 2, the 4th issue, whether a live application for reserved matters approval and condition discharge can be switched from one parent planning permission to another after the deadline, as a matter of principle. And finally, whether on the facts of the case, it could be done here. And I'll also deal with discretion under that issue 5.
Yeah. You can take it that we've read the judgment and we've read the skeleton arguments.
I'm very grateful for that. The facts so far as relevant are very helpfully set out by the judge below, and we've provided also a chronology which I hope gives some orientation. There are some extraneous matters there that pertain to grounds that have now fallen away, but that chronology is at pages 144 to 146 of the core bundle. In broad outline, I'm going to touch on the facts so far as they relate to matters in dispute, and not go to points that don't. So far as relevant, the outline permission was applied for in 2016, granted in 2022 for 170 dwellings. There are 3 conditions of particular relevance to the dispute now before this court. Those are conditions 1, 2 and 13, which I anticipate the court will have read, and I'll come to the wording of in due course when we get to the question of interpretation. An application was made for discharge of conditions and reserved matters in May 2023. That application you'll see is actually for 153 dwellings rather than 170. It matters not for the issue before the court.
So an application for the discharge of which condition?
The discharge of conditions and reserved matters. We'll come on to the question of which conditions were applied to be discharged.
And for approval of reserved matters. Yes. Right, okay.
The application form is at page 444 of the core bundle. See it? Sorry, that's the decision notice. It's at page 44, which shows the decision under challenge. The application form is in supplemental bundle, page 21. And to answer my Lord's question, that gives a description of the development being applied.
Sorry, which page? 21?
21 of supplemental. That's the application.
The bundles have come apart.
That is the application form at 21. 2 pages on.
Well, just before, yes, you're going to page 23.
I'm going to page 23. Yeah. Page 23 provides a description of what is being applied for, reserved matters being sought. That's in the section marked development description, the bottom box in that section. Reserved matters being sought for appearance, landscaping, layout and scale for 163 dwellings, and discharge of condition 22 and condition 8 of the outline planning permission.
Yes.
remaining in the supplementary bundle, if we may.
And by date, that must have been in relation to the outline planning commission.
Well, it says in terms,
Yes.
doesn't
Yeah.
it?
Yes, and it in fact, my lord, indeed predates the Section 73, which
Yeah.
was only granted on the 10th of December.
So it's got to be an application, whatever it is, in relation to the OPP.
Correct. Turning, if I may, to page 194 of the supplemental bundle.
Sorry,
It's a
page-
document that should be a rather large table. I'm afraid the text is small, but it wasn't really a realistic way of blowing it up.
Which page?
194 of the supplemental.
Well, those of us working electronically have no difficulty in making the page larger.
On the other hand, we dinosaurs.
No comment.
At the moment, I can't even manage the bundle, you can read it.
My lord's there. This is described as a conditions compliance table, submitted, as the appellant understands it, together with the application or shortly thereafter. We don't have this document doesn't bear a date. I'm sure you can ask the respondents if they can elucidate on the exact date, but it's, I think, common ground that it was submitted at some stage as part of the RMA.
Is it part of the application then, or is it a separate document, just like I could write in a letter?
Well, it addresses the application, whether it was submitted at the same time as the application itself.
Is it part of it?
It's-
Is it a later comment
In
on
my
it?
submission, it is part of the application in that
Okay.
it seeks to explain and summarise the position in respect of the various conditions.
Okay.
And as we'll come to, and I think it was in my Lord Justice Dove's mind when asking the question on Monday, the Reserve Matters Approval application was amended a number of times. Some of those times there was a new application form submitted, but the vast majority of times there was not. There was simply a superseding of a previous document. I think, for example, landscape plans were superseded 6 or 7 times, for example. That is fairly normal in the lifetime of such an application, that there'll be discussion and a new document will be submitted. Which makes, I think, my Lord's question a slightly tricky one to answer insofar as was it part of the application? Well, yes, albeit not at the time the application was necessarily made. My Lords will see condition 13 is at 196 of this, 196 of the supplementary in this document. And that says there is compliance with condition 13 in a green box. And if one, the box immediately to the right of the green box simply recounts the condition, and then the box on the right explains. And it says there is compliance on the basis that a foul water drainage scheme was submitted. And there is also reference to other conditions in other stages. The pattern in this document, which I might come back to in due course, is that where a condition has the preamble that links it to condition 1, you'll see the box on the right says a document or documents have been submitted. The details have been submitted pursuant to the condition.
So
So
this effectively disaggregates condition 13 into those elements which will inform the reserve matters application for the reserve matters design, and those matters which still have to be addressed to discharge condition 13 in relation to what needs to happen at Buckingham Water Treatment Works in order to accommodate the foul water capacity generated by the site.
in a sense, my Lord, insofar as...
Well, I'm just wondering what foul water drainage scheme might be.
Well, I think it may now be the position that there was no such document submitted.
No, but it may be that the plans, which I haven't seen, would show sewers, other elements of the foul water drainage scheme insofar as it was pertinent to those matters the local authority needed to determine to discharge the reserve matters about the appearance and design of the development.
The plan does show broadly what my Lord...
Well, that was the purpose of one of my inquiries, so I'm very grateful. Thank you, Mr.
And I
Welsh.
think my learned friends have brought those plans along, albeit with a slight hesitation on all of our parts that those plans were not before the judge. Nevertheless, she did ask questions about them.
do
We're
love
all
a
happy
plan.
for them to be handed up. We're all happy for them to be handed up.
Well,
if
don't
they
do it. Don't
exist.
detain yourself now. But yeah.
Yeah.
So what, just to recap, what are you telling me that section page 196 does and doesn't do?
Page 196 describes whether the condition in question is complied with on the basis of the materials that have been submitted in the applicant's view.
And you're saying
Respondent's
this
view.
says what? What is the description here that you say it's making? So I got it clear.
It's explaining that it says there is compliance with condition 13 by virtue of the documents that have been.
But you're saying there are no documents.
Well, there are some documents. The full suite of what was required under condition 13 was not, as it turns out, submitted at
No,
the
what
time.
was provided was the first sentence of condition 13, namely, when you do your discharge of reserve matters, don't forget you've got to put some sewers on the site.
Well, in my submission, condition 13 goes a bit further than that because it ties all the matters that it contains to the condition 1 process, which is to the reserve matters.
Well, that's a question of
This
interpretation.
is a question of interpretation.
Yeah.
So far as it goes, with this document, the pattern is similar between conditions 11, 12, 13, 14, 16, 31, 32 and 34, and I will come back to those. Insofar as in each of those conditions we have the same preamble. And the preamble that says the details to be submitted for approval in writing by the LPA in accordance with condition 1 shall include, and then there are various documents listed. So for all of those conditions, which are not specific, you'll recall, not specifically listed in the application form, because that only lists reserve matters and conditions 8 and 22, but for all these other conditions that have this preamble that the appellant submits ties those conditions to condition 1, there are
I don't
documents
understand
submitted.
what you mean ties. It doesn't make it a reserve matter, does
No,
it?
it doesn't make it a
What
reserve
it
matter.
says is that if you're going to seek approval of this other thing, which is not a reserve matter, you've got to do that within the time scale and in writing.
Yes.
Is that right?
Yeah, I'll come to the focus question of interpretation of conditions 1, 2 and 13 in a moment if I may. The next stage in the process from this, after this conditions compliance table, for the court's purposes, is the 12th of June letter from the second respondent agent. And that's at supplemental 202. It's a letter from the second to the first respondent, 12th June 2023. This refers to the drainage capacity statement being a work in progress.
And in English, the drainage capacity statement, is that a new description of the thing that's described in part 1 of condition 13?
Essentially, that's the foul water drainage scheme, as I understand it. Well,
Does it
forgive me, that's the first part of the foul water drainage scheme, because a scheme would explain how any necessary upgrades will take place. The
This is
assessment,
directed towards the upgrades to Buckingham WTW, isn't
yeah,
it?
but they're only identified as required once you've undertaken an assessment.
Yes, I understand that. So when it says drainage capacity statement, is it describing the things in the second sentence of part 1 of condition 13?
It's part of that, yes, my lord.
I take it that Miss Pilcher is at the planning authority.
Yes, the first respondent. Moving on to supplementary 205. And we haven't put before you all of the correspondence with Anglian Water as to the issue with upgrading Buckingham WRC, but I think if my lords have read the judgment, Mrs.
Yes.
Justice Lang, they will have got the flavour of it. This letter then of the 20th of September 24 it illustrates that the second respondent was struggling to obtain a foul water drainage scheme, including the wastewater treatment capacity assessment and whatever scheme was necessary to provide upgrades, because Anglian Water, who are responsible for undertaking those upgrades, did not have funding for such a scheme. So
It's the assessment of it's the document that's got to be included in the foul water drainage scheme, which is the assessment of upgrades needed. That's what they're struggling with.
it's both the assessment has been undertaken by this stage as to what is needed, but it's the scheme for providing the necessary upgrades that cannot be provided because there's no funded scheme by Anglian Water at that stage.
They appear to have had the money, but spent it on something else.
That goes to issues.
Is that harsh?
Not for me to say, my lord.
No.
The background to it is set out by Mrs. Justice Lang, and in essence, yes, Ofwat told Anglian Water, you can't have more customers' money to bring your WRC back to the level it should have been at already, bearing in mind the customers' money you're supposed to have spent on it. And that the plans that were proposed to upgrade it would only, in any event, in Ofwat's view, take it to a point of compliance and not allow for future growth. That is essentially the position.
I'm just finding the sliding over of words difficult to pin down. Condition 13.1, the first part, says there should be a foul water drainage scheme for the site, full stop. That scheme shall include, i.e. it does not consist of, but shall include a wastewater treatment capacity assessment. So there's going to be a second thing, which is part of the drainage scheme. And that assessment will do two things at least: identify the need for infrastructure upgrades and a programme for carrying out the work.
Yes.
So it's helpful to say which parts of those.
Forgive me,
There are four
I think
things
I've
there.
eventually got my lord's question, which is yes, it is the programme for providing the work.
It's the programme for providing the works, okay, that you're saying hasn't been done, yeah. I'm sorry to be...
No, entirely justified. And so you'll see when we go back to that letter on 205, the third paragraph from the bottom refers to no detailed programme for the upgrades having been provided by Anglian.
So that's the bit that we're dealing with then.
Yeah.
And is this also the application under section 73?
Yes, so this is the rationale for that application. I'm going to come to those parts of the letter just to emphasise a few points. So over onto page 206, fifth paragraph down begins, this application therefore seeks. Fifth paragraph down on 206.
Yeah.
Seeks to reword condition 13 to read the following, which allows the current reserve matters application to be issued in Anglian Water to provide a programme for the upgrade of WRC. So whatever might now be being said about whether the understanding was correct, at this time the section 73 was being advanced to get around a perceived roadblock to issuing the reserve matters decision. That's expressly the basis on which the section 73 was being advanced.
But I thought everyone agreed that was mistaken.
Well, we'll come to that. We'll come to that because that turns on the question of interpretation ultimately.
All right.
And indeed, the respondent's position seems to have moved on from that, as my lord says. The section 73 permission is set out. I don't think I need to take this in much detail, but it's set out at 26 to 30 of the supplemental bundle.
Which page?
26 of the supplemental.
Yeah.
And this is the decision notice with further with the conditions on. And we're not going to go through all of it, obviously, but there are two relevant changes from the Outline Planning Commission, conditions 2 and 13. Condition 2, rather than saying approval for reserve matters no later than 18 months, it says no later than 18 months from the date of the Outline Planning Commission. Condition 13, as I think my lords will have picked up from the skeleton arguments, is the same, save that the first paragraph has been removed. So condition 13 read as it is on the section 73, it is simply a preoccupation condition. There's not that linkage to condition 1.
Yeah.
But I think the last document in this chronology to go to is at 249 of the supplemental, if I may. And that's a letter.
Sorry, 249.
249.
Thank you.
And that's a letter from Mr. Scott to Ms. Pilcher. That again is Carter Jonas on behalf of the second respondent, the developer to the LPA, common parlance. Asking that the description of the live reserve matters application be amended
Yes.
to refer also to the section 73. And that request was evidently acceded to, given the decision notice under challenge.
Yeah.
And my Lord to also observe that no new application was made at this stage to discharge reserve matters on the section 73 itself. That really will take us to the core of some of the arguments under ground too.
But to help a non-planner, can you tell me what the word discharge means?
Yes.
There are three
Yes.
things. Vary, that is you alter it by taking it out. Discharge, you remove it, I thought. And comply, you satisfy its requirements. Which of those three states of affairs do you mean here?
In relation to the reserve matter, in relation to the decision under challenge, it is a discharge, that is an approval of the details required.
Saying you have complied with the
Saying
condition.
the details you've
approval,
supplied are
okay.
acceptable to the local planning authority.
Okay.
Whether that's the reserve matters.
So you discharge a condition by complying with it, in effect.
In this case, yes.
Because there are different types of condition. Some may be effectively time limited or time bound by, for instance, occupation or, for instance, commencements on site. And therefore, before you occupy or commence, you need to comply with them, i.e. discharge them and show you've done what is required. Then there may be other conditions which require a control of the use that's taking place, or the protection of, for instance, open spaces within the development, which is not time-bound.
Absolutely.
But what you're dealing with here is the discharge of a time-bound condition to enable the development to take place in some way, shape or form.
That's right, Lord.
There's a confirmation by the authority that in its view, the legal requirements have been met as set out by that condition. Is that right?
Yes, that's right. And I think my learned friends have taken the point that some of the drafting in my skeleton argument appears perhaps elides the different nomenclature. There is a making of an application that is obviously different to the decision on the application to discharge it. There's no issue there.
Yeah.
We turn then to the officer's report advising members, because this was put before committee, as to why it was that the application should be approved. That's at 41 of the supplemental. And 1.4 on 42 says amendments have been received. I mean, that just, I think, confirms the point I was making earlier, that in the normal course of things, there are lots of amendments to applications by the submission of new documents. That's just the way it goes. 1.6 addresses the important issues here. There's reference, in fact, I think rather than me read it out, I might let my lords read 1.6 so far as it goes on page 42 and 43, if I may allow the court to do that. That again confirms the interpretation that the appellant advances today, essentially, that the reserve matters scheme did require the information under condition 13. That was the interpretation that the local planning authority had at the time of the decision.
And when you say information, do you mean more specifically the programme of works?
In the case of condition 13, the programme of works, yes.
You're saying the approval of the programme of works is a necessary part of and is a reserve matter?
No, it's not a reserve matter, my lord.
Ah, right.
No, we don't say it's a reserve matter. As a matter of construction of the outline planning permission, the local planning authority chose to tie those details to the reserve matters.
To tie them to it, or to tie them to the process for applying?
To the process.
Oh, thank you. Yeah. Yeah.
Turning towards the end of the report at page 99 of the supplemental bundle. Starting at paragraph 5.194, my lords will see the heading of this page is discharges of conditions in bold. And then it says the following conditions from the outline approval are considered as part of this submission. Condition 8 and condition 22 are first.
Yeah.
Yeah, and after that, we have a number of other conditions requiring detail to accompany the reserved matters application. Can my lord see the text above 5.196? We have condition 1, and just above that text it says other conditions requiring detail to accompany the reserved matters application. And this then runs through a number, but not all of the rest of the conditions on the outline planning permission.
Yeah.
My lord's notes, conditions 11, 12, 13, 14, 16, 31, 32 and 34 all have this same preamble that cross-refers to condition 1. And I'm not going to go through each one in a great deal of detail, but in each case one sees the same thing, details submitted, and the officers here considering those details and deeming whether they're acceptable or not. And this, I think, is confirmed most strongly by condition 14. So over the page on 101, this is not obviously a condition in issue, but this does confirm the interpretation the appellant advances. So 5.203, beneath that, there's a reference to condition 14, same preamble, and this relates to parking and manoeuvring and various other transportation matters. And it's 5.204 that I'd like to draw the court's attention to, which says details have been submitted to address the above requirements of condition 14. Then the next sentence, however, the detail in respect to the specific charging capacity has not been fully provided, and as such a further condition is imposed to require this detail. In respect of other matters, the submitted detail is considered to be acceptable, and as such this condition has been discharged.
So one way of looking at that is that insofar as pertinent to the matters that are properly reserved matters, there has been compliance, but there has not been compliance in relation to something which is not a reserved matter, but which nevertheless has therefore been made a condition of this reserved matters approval and will require discharge by the submission of further details.
Yes, and in terms of compliance with the conditions, there obviously was in the case of condition 14, there was submission of information, almost sufficient information for the decision to be made, but there are further things required that flow from that. And that if one goes through the decision notice, there are quite a number of issues where it says, notwithstanding the details submitted, could you also provide this? Could you also confirm that? That's the consistent pattern. But that is consistent. This is why it's important. That is consistent with the appellant's submission that the application for reserved matters approval and discharge of conditions 8 and 22 also considered a number of other conditions, because that was the LPA's correct understanding of how the outline planning permission worked. And indeed, a decision was made on whether those other conditions could be discharged. That's why we see the language here of the condition has been discharged. The condition can be discharged. Now, the wrinkle in this, which led the judge below to find against me on the point and say essentially, well, the decision notice doesn't list the discharge of these conditions and the application form didn't. In my submission, it is very common for conditions to be discharged through a more informal process than being recorded fully in a decision notice. That is the reality position. Often in small planning applications, and at the risk of giving evidence from the bar, an officer will respond to an applicant simply saying, thank you for the information, this condition is discharged. This is acceptable. Now that is, I hope my lords are familiar enough, I know, with some planning cases to have probably seen this take place. It is not the case that simply because the decision notice omits to refer to conditions 12, 14, all those other ones being formally discharged, that they weren't discharged. that makes a nonsense of what the officer's report is saying in this section.
Just so that I'm clear, you're saying that condition 13, first part, is tied to the process in part 1, so any application in relation to the matters in 13.1, I'll call it, has to be in writing. It's got to be approved by the local planning authority before commencement. And what I'm not so clear about is whether you're saying, and it's got to be done before or at the same time as the approval of the reserve matters, or whether or not they could do it before approval of reserve matters, at the same time of the approval of the reserve matters, or months later, so long as it's before the commencement.
Well, the answer is it has to be with the reserve matters.
Because that's your interpretation of condition 1.
Yes, I'm coming to absolutely
So condition 13 has to be considered and approved or refused at the same time as the application for approval of reserve matters. Is that right?
That's right. And I'm moving on to that question, that focused question of interpretation now, having concluded on the facts. In terms of the principles of interpretation of planning permissions, I don't feel I need to spend much time on this, because I think you're probably familiar. The principles are agreed. The DB symmetry case helpfully sets those out, as does the Lambeth and Secretary of State judgment of the Supreme Court. The only point that is not in dispute as a matter of principle, but its applicability is in dispute, is the validation principle, which the first respondent has cited in reference to the Section 73 permission, and said essentially, well, the appellant's contention makes a nonsense of the Section 73 and would make it invalid, so it can't be the right interpretation of that. I'll come on to that. It's not really a dispute as to the legal principles, it's more about how they apply. Turning then to the conditions themselves. Supplemental Bundle A, page 5. And the short point, as I answered to my Lord Justice Lewis, is that condition 13 is tied to the reserve matters approval process. Condition 13, which is set out on page 8, and has the same preamble as a number of other conditions, requires details to be submitted.
Shouldn't we start with condition 1?
Yes.
We certainly can do.
I mean, we have already, but I mean, doesn't the whole case start with condition 1? And
Condition 1.
Then you're going to go to one of the many conditions, condition 13, which has a clause which talks about what needs to be reflected in the reserve matters.
Yeah, absolutely. Condition 1, on its own wording, is only about the reserve matters. So you will see details of the appearance, landscaping, layout and scale, brackets, the reserve matters, shall be submitted to and approved in writing by the LPA before any development begins. The development should be carried out as approved.
So all that tells me is they've got to be in writing, approved in writing, and that's got to be done before commencement.
That's right. That's the reserve matters. That's what condition 1 says.
So it doesn't tell me that if there can be 2 or 3 or 5 applications in relation to different bits. Presumably I could have one appearance application, one landscaping application in different months and approved in different months. They don't all have to be dealt with at the same time.
They don't all have to be applied for at the same time. The only limitation on that is what we find in condition 2, which is that that's the long stop date.
That's the 18 months. But all we know is that any application for anything that's to do with reserve matters has to be in writing and approved and before the commencement. It doesn't tell you anything else about whether it's got to be all of them or some of them.
Correct.
Breaking back to your observation about the committee report, would there be any reason why, if the details of the wastewater treatment capacity were not submitted along with the plan showing how foul water was going to be treated, the reserve matters application could not have been conditioned to say, in the same way as the electricity charging point, you've still got to do the discharge of how you're going to deal with this at the water treatment works?
Whether that could have been conditioned would turn on whether it would have been reasonable to impose a condition in circumstances where there was no funded programme for that upgrade.
Yeah, well, that's a question on the merits. I'm asking about the principle, but in principle, there could be no objection to doing that.
I can't deny that.
No.
Condition 1 then, I think the main point I want to make about this is that it is only about reserved matters. It is not a condition about any other details required under any other condition. So if you read condition 1 on its own, it's just about one process. Admittedly, as my Lord or Justice Lewis correctly said, there could be multiple...
I think you said condition 1, but you meant condition 13.
No, I'm talking...
You're back to condition 1, are you? Okay. Right.
Condition 1 could be... there could be multiple submissions under condition 1,
Yeah.
but so far as condition 1 is concerned, it is only about reserved matters. It's not about broader details. There's reference to details, but they're then defined as the reserved matters. Condition 2 then tells us the long stop date for the condition 1 application or applications. And then we do come to condition 13, over on page 8. Condition 13, which requires details to be submitted in accordance with condition 1. My submission in accordance means in accordance with whatever it is that condition 1 requires.
Well, that is writing, approval and time, not together with anything else. We've just established that.
Yep.
So you've got to do it in writing and before commencement, but it doesn't mean, does it, that you've got to do it at the same time as something else.
But because it has to be part of the reserved matters.
Yes, but we've established that the reserved matters can be dealt with in tranches and at any time up to commencement. So if they did 3 of them, appearance, landscaping, layout but not scale, there wouldn't be a breach of condition 13.
Yep.
If they did part of the 4th one, scale, wouldn't be a breach. If they did all of the scale, wouldn't necessarily be a breach. I don't see the thing that says it's got to be decided, applied for, decided at the same time at the moment. As
The limitation, it has to be, well, it's tied to the process for the reserved matters application, whether that's one or multiple.
Well, I think tied is the wrong word. It says that the process has to be followed. The process that you use for reserved matters has to be followed.
Yes.
But it doesn't have any words about timing in, and the suggestion or the use of the word tie, which isn't in the condition, is an attempt to introduce time.
It's a gloss, I fully accept
Yeah.
that. But it's the process under condition 1
That must be followed. Let's
that
avoid
must
tied.
be followed. And it's that, as I said, condition 1 is subject to condition 2.
Yes, it's got
So
to
it's
be
not possible
within
to,
18 months, and it's got to be before commencement.
it's not possible to be in accordance with condition 1 without also being in accordance with condition 2,
Yeah,
because
this application.
I don't follow that. Condition 2, condition 1 is, because of the drafting of this permission, pervasive throughout this planning permission. Condition 2 is a carve-out, which applies only to reserve matters.
Yes.
yes, but condition 1 on its own face only applies to reserved matters.
Yes, and condition 2 only applies to reserved matters. But condition 13, which doesn't apply to reserved matters, says the things you've got to do in condition 1, but not condition 2, applies to the following thing, which is quite different from a reserved matter. So it's the process, but not the timing, other than the commencement.
In my submission, it's not possible to read the process outside of the timing, because it would involve separating out the reserved matters as they're defined under condition 1 and condition 2.
Right, well, we've got that point.
We've got the point. And the error in my submission with the respondent's approach is that it assumes that condition 1 provides a generic pre-commencement deadline outside of what it says for reserved matters. A deadline for submission other than that which is caught by condition 2. The condition 13, along with a whole host of other conditions, by being tied to condition 1, is therefore tied to condition 2.
Yeah.
And the respondents have cited the North Norfolk case to say, well, condition 13 is like that, is like the condition in that case. I don't think we need to go there. But in answer to that, that was a condition that was self-contained in that it expressly said pre-commencement within that condition in that case. It wasn't like the condition here where there's a linkage to the reserved matters condition. So in terms of interpretation of the Section 73 permission, there is an issue between us as well, because my Lords will have seen Condition 2 deadline under the Section 73 is in the past.
This is the same point, is it? The interaction between conditions 1 and 2.
Yeah. And there's a debate about what it means that it says in the past. The respondent's reading of this deadline it's probably helpful to go to the Section 73 decision notice itself, and that's at 26. Supplementary. And that's Condition 2, which we saw says no later than 18 months from the date of the Outline Planning Commission. The respondent's reading of this deadline, which means that it simply incorporates the applications already made under the Outline Planning Commission, is not it's not a point that was taken in the High Court. Why should that matter? But it's not supported by the wording of the permission or by any other documentation. And the officer's report for the Section 73 permission is in the bundle. Again, we're not going to go through it to look for something that's not there, but that doesn't make this point at all either. So it is a new point that was not, in any sensible sense, part of the rationale for this wording of Condition 2 under the Section 73.
But it makes sense, actually, because if you're right and everything is tied into Condition 2 in 18 months, there's no point in getting the 73 permission because it's all too late. But if it's only the reserve matters that has to be done with 18 months, but things that aren't reserve matters, although they have to be in writing and pre-commencement, but aren't tied to 18 months, then that means that the Council was doing something which had a legal effect when it granted the Section 73 permission. So that's rather against you, isn't it?
That distinction is probably right. But stepping back, the reason behind my interpretation, as it were, and the Council's initial interpretation of the Outline Planning Commission, is that it's very difficult to have your reserve matters approved before you have all the information and details assembled for all of the other conditions.
We don't need the programme for infrastructure works because that doesn't affect the site.
Well, you might do. I mean,
Well, you might not, but the question is whether it's critical. And the only thing that could be critical, I suspect, would be the dwelling numbers, wouldn't it? In terms of what needs to be done at the water treatment works, because that tells you what the load on the water treatment works is going to be. But you wouldn't need to know about the upgrade of the water treatment works for any other of the things that are appearance, landscaping, layout or scale.
Well, but the two plans that we're told were, which my then friend proposing to hand up, the two plans that we're told did accompany the reserve matters application and did speak to Condition 13 in part, albeit they're not a capacity assessment and they're not programmed for upgrades. Those plans necessarily require the layout to be fixed because they are plans showing the drainage arrangement. This is why I say it's not possible to have your reserve matters, which includes all of the points, appearance, landscaping, layout and scale, fixed, and then come back and apply for the details under the conditions which might include, in the case of Condition 13, the plans my Lord's looking at, which might have had, for whatever reason, to be different. Similarly, the car charging.
If there's something to do with the infrastructure that's outside the site, then it's irrelevant. If you're saying that there's something that would have to happen within the site for, I don't know, some enormous big pipe straight through the new oak trees, well, they can't do it because it wouldn't be approved, would it? So isn't the answer, if they're going to do anything for infrastructure, which involves some physical change to appearance, layout, or whatever it is, they won't be able to.
They won't be able to, and that's the policy reason, in my submission, behind why the permission was put together as it was, the outline permission, in that all these other details were linked to the reserve matters process to prevent a situation like my Lord envisages.
Yeah,
It is a sensible approach, I mean, perhaps has given the developer a lot to do in the space of time it's had, and it's not been able to do it. But there is sense to that approach.
But then it had to engage with reality.
But then I have to engage with reality. The question of the validation principle, which is cited by the respondents against me, they say, well, this rider to condition 2 in section 73 can't mean what the appellant says it can mean, because it would mean section 73 was without any value. The issue here is not a question of whether it's invalid as a matter of interpretation. It's about whether it's of practical utility to the developer in the real world. And one may have many situations where a permission is valid, but for whatever practical reason is of no utility. The Hill case, which we have in the bundle, is an example of precisely this situation. And that's a case which concerned 2 appeals that were made, but there was no application made and no appeal made to extend a time limit condition. So the inspector went ahead and determined the appeals, but was not asked to extend the time limit condition. And the judicial review is essentially, well, the decision is a nonsense, because even though he's approved some of the changes, because he hasn't extended the time limit, the permission is of no value. And I think we'll come to the Hill case when I address ground 2. But essentially that argument that it was invalid, therefore, did not fly. The point was that the inspector was not asked to discharge condition 3 as it was, which is the time limit condition in that case. So that's a helpful example, an illustration of why the validation principle doesn't really assist the respondents here. I then move from interpretation to issue 2, which is the facts of the reserved matters approval application. I have already dealt with these in detail.
So wait a minute, you
My submission on the facts.
issue 2, right? Yes, sorry.
My
Still under ground 1.
We're still under ground 1,
Yeah.
yes. My submissions on the fact of reserved matters approval I can take pretty briefly, because
What have you shown us?
I've shown you the facts.
Yeah.
In overarching, because of the interpretation of the Outline Planning Commission, the second respondent had to and did seek to discharge a number of conditions, including condition 13. And the fact that not all of the information that was required was provided doesn't mean that they didn't make an attempt to discharge it. There was an attempt on facts to discharge condition 13, albeit an incomplete one. And what happened with the section 73 was that the goalposts were moved, as I put it colloquially. That moves us on to issue 3.
Before we get to issue 2, if you're wrong about your interpretation and say you don't have to put the infrastructure programme in at the same time and have it decided at the same time as them, if you're wrong about that, then the position at the moment is that so far as the Outline Planning Commission is concerned, paragraph 13.1 still remains, and if they're applying or if they're trying to implement that Outline Planning Commission because they've got approval of reserved matters, they can do so, but they would still have to do, before commencement, on this hypothesis, put in the programme.
On this hypothesis, I think that's correct.
Yeah.
If you're against me on interpretation.
Yeah.
I should say, if one also against me on the interpretation point, that does certainly not sink ground 1, because the court, as we'll come on to, when looking at whether there's a substantial alteration, has to have regard to...
It's a different issue.
It's a different issue.
Yeah.
The interpretation is
on
relevant.
the interpretation, if you're wrong on your interpretation, the position is they applied for approval of reserved matters under the Outline Planning Commission. They've got it, but they still need approval of 13.1 before commencement. Or they need to get rid of it in some other way.
So,
Now, if that's right, Mr. Welsh, how does significant or substantial change come into the picture at all? On my Lord's hypothesis, they've still got to comply with the whole of condition 13, except they've got to do it pre-commencement. So what changes that?
the change is that the application that was considered and determined was one that omitted those details, any details under condition 13.
But
whereas as applied
the decision notice doesn't say they have discharged condition 13.
No, it doesn't say, and for the reasons I've
So
given.
So if you're wrong on interpretation, they've still got to do it.
They've still got to do it, but that doesn't, in my submission, take away from, as a matter of fact, and the court has to assess whether they did attempt to discharge condition 13, and by the end of the process, last year, they'd taken that away and they no longer did. Whether they still need to do so is of course relevant, but it doesn't take away from the question as within the lifetime of that application whether there was substantial alteration.
So I'm not with you. There is a question. There is a question of interpretation, and if we're against you on that, and this is an hypothesis, they've got approved or reserved matters under the Outline Planning Permission, but they have paragraph 13.1 to comply with still before commencement on this hypothesis. I can't understand what question of fact arises, because if they say to you, no, we've discharged condition 13, the answer is no, they haven't. And I can't see, as my lord says, why substantial alteration is relevant, because you haven't altered anything in the Outline Planning Permission.
It's a question of whether the application for discharge of reserved matters was altered during its currency and after the deadline had expired for making that application. And I'll come on to that in a moment. I can see the force of my lord's questions.
It's whether the application for reserved matters was altered rather than whether the planning permission, the Outline Planning Permission, was altered.
Indeed, my lord.
Yeah.
So on issue 3 then, there is, as in terms of legal principles, there are two cases. There's Inverclyde and there's Hoven Studios.
Before you turn to the cases, I'm sorry to be grim, but I'm just finding this very difficult even to understand.
Yeah.
What is the alteration that you say has happened in the application as was, and some subsequent variation that is substantial? Just the addition of those words at the end.
It's two things.
Yeah.
It's first that there was some attempt to comply with condition 13 as part of that application. And my lords have seen the conditions compliance table and the other documents.
Yeah.
And it's second that the respondents say the reserved matters approval application was transferred from the Outline Planning Permission to the Section 73.
Yes, it's not variation. They say as a matter of law it now means that the second document you've got is the one that you're acting on, and you say no, it's not. It can only ever be the first one. And if you're right on that, then they've got to do the programme anyway. Yeah, okay, I'm with you. I understand what you say is the variation.
Issue 3 then, as a matter of legal principle, there is an implied, the courts have found an implied and limited statutory discretion to allow the alteration of live, I'll call them live reserved matters approval applications after the deadline for applying has expired. So at the point in time, this is post 24th September 2023, after that date, the 18 months under condition 2 had passed. So it was then too late to make a new reserved matters approval application. The courts have considered, particularly in the Inverclyde case, whether after that deadline you can nevertheless change something about the application, or whether you're shut out completely because the deadline has passed. And the test for that is whether there is an alteration, a substantial alteration, various other formulations to the application that's been made. If it was this, like go to the Inverclyde case itself. That's in the authority fund at tab 5, page 65. It's rather a long paragraph, I'm afraid, but page 65, internal 397. His Lordship says, about halfway down the page, there's a sentence beginning, there is, however, one obvious limitation. And that's been applied in the English courts, for example, in the Holborn Studios case, which I think I incorrectly attributed to my Lord Justice Dove, who was involved in
That was another one.
a different iteration of similar litigation.
Been in the court several times.
Forgive me for misattributing it. It has been in the court several times. That essentially applies the Inverclyde principle in English courts. The respondent says against me that the test for whether there's a substantial alteration is effectively subject to Wednesbury.
Sorry,
because it's a judgment.
where do you get this substantial alteration from? Because what the Inverclyde case says is that you can't have an amendment which would have the effect of altering the whole character of the application so as to amount in substance to a new application. It doesn't say you can't have a substantial alteration. It says what you can't do is have, in effect, have a new application. So where do you get this no substantial alteration test from? Because it's not in here.
Forgive me.
It's not in here.
No, from the language used by John Howell QC, as Deputy High Court Judge in the Holborn Studios case.
Right, where's that?
That's at 297 on tab 14 of the authorities bundle. Paragraph 65.
So before you, what was actually happening here? What was being amended?
This is discussing whether a planning permission a planning application may be amended.
Right, okay. And you want us to go to paragraph?
65. And it's the last sentence of that paragraph that begins the substantive limitation, whether the change proposed is substantial or whether the development proposed is not in substance that which was originally applied for. So slightly different language used for the test.
Right.
So it's taken against me that, well, this is essentially a judgment for the local planning authority to make as to whether there was a substantial alteration, and that judgment is subject to only Wednesbury review. That being so, I think I have to accept that is the case. My submission is that we do meet that.
So, in order to determine whether it's a substantial variation, if that is the test, the question isn't, is it a substantial variation? It's whether a decision by the council that it's not a substantial variation is irrational.
So my submission has to be, and indeed it is, that we meet the Wednesbury threshold if that's the angle at which the court comes to the question.
Having clarified the test, could we just, if my lords will forgive me, just return then to what you say the alteration is, or the alterations were, which to the reserved matters application to which that test should be applied?
The alterations then, the reserved matters application was advanced on the basis that the details under condition 13 were required to be submitted. And indeed, at least some details were submitted, albeit an incomplete suite of details.
What you said earlier was that there was a substantial alteration because of two things. First, there was some attempt to comply with condition 13. And second, the application for approval of reserve matters was transferred, purported to be transferred, to the Section 73 Planning Commission.
Yeah. Those are the two limbs, essentially.
Yeah.
And
I don't understand the first one. Some attempt to comply with condition 13. So what? If it's not complied with, they've got to comply with it.
they have got to comply with it, but
So why does the fact that they had to go and got it wrong make any difference?
because the point is after the deadline for after the expiry of the deadline for submitting a reserved matters application,
This goes back to your.
their
That's your
discretion is limited.
interpretation.
This goes back to the construction.
Yeah.
Their discretion is limited. Yes, it does go back. That does go back to the construction point. The discretion is limited after that point in time.
Yeah.
I suppose I would say, even if my lords are against me on the construction point, as a matter of fact, there was something submitted, and then during the currency of the application, by the end of the process, there was no longer an attempt to discharge condition 13. That is a change.
Yeah. Yes.
But if we're thinking about it in rational terms, a change without consequence, because they'll still have to provide the details of the upgrade to the water treatment works or whatever other infrastructure solution off-site's required, won't they?
But they would have to, but as a question of whether they... That I think is a discretion question, ultimately. If I may respond in that way.
And on the second point, if they're wrong, and as a matter of law, they can't transfer it. They applied for approval of reserved matters under one permission, the outline planning permission. That's what they got, and they can implement the outline planning permission, but it's got condition 30 in. They can't implement the section 33 permission because they haven't got approval of reserved matters. So there's no substantial alterations, just they lack approval of the 73 permission reserve matters.
Well, they'd have to comply with condition 13 prior to commencement. Therefore, they'd have to have a solution prior to commencement rather than one prior to occupation.
If that's the correct analysis, that they didn't have a power and they in fact didn't transfer the live application from one permission to another, then that's not the basis on which they thought they were making the decision.
Yeah, well, I mean, what's wrong with, isn't it, not my field really, but isn't it just a question of reading the decision to see if they've got, and if it's approval of reserved matters under the outline planning permission or under that number, then that's what it is. And if they refer to it as varied by section 73, they're wrong, because that's not what a planning permission does under section 73. So this sounds like you're making a mountain out of a molehill. It should be solved by reading the decision letter.
That I think probably takes us into ground two as to whether they could do what they thought they were doing. So yes, as my lord says, there is that second strand to the argument under ground one. That is, they thought there was a swapping from one permission to another, and that too, I say, has to be a substantial alteration. It is hard to envisage.
But don't we need to look first, as I keep saying, at what they did and see if that's what the decision does, swap it. And if it is swapped, then you have to ask, is that valid? I don't think it's a substantial alteration, or it could be. So is it 444 that we need to look at?
That's the decision under challenge, I think.
Yeah, and that's what you're saying is the thing that's substantially altered, because it granted it for the 73 permission and it was applied for this OPP.
Yes, that essentially goes to the second limb, round one. So
And that says
444
reserve matters being sought for appearance of outline approval, then it's got a number, which I assume is the first one, is it?
It is.
That's the outline plan
Yeah.
permission.
The words as varied by the application is either meaningless or it's misleading, because it doesn't vary that planning permission, it grants a new one.
Yeah.
So they've got OPP approval.
Well, that was very much my client's case in the High Court, was that if you read this, the only proper interpretation is that they got OPP, thought they were getting OPP approval, and thought they could stick on Section 73 to mean they didn't have to engage with Condition 13. I mean, that is the only construction that supports my interpretation construction, of course. It's the only construction that makes sense of why they needed to get the Section 73. Because if I'm wrong about the interpretation, then there was no need to obtain a Section 73 permission in the first place, as a prerequisite, and indeed it was a prerequisite to the grant of this reserved matters application.
Yes. So your ground two is answered by the form of the decision notice. It wasn't transferred.
Well, in my submission, it wasn't transferred. They thought they were transferring it, but it wasn't transferred. But I do need to address the submissions made by my learned friends that, in fact, it was transferred and they had the power to do so. If I can assist, I will do so on that. Just before I move off ground one, if I may, I just wanted to touch on discretion, because it's a point made by the first respondent on ground one. And that rests on the court being against me on interpretation. So strictly speaking, it's only a partial section 31(2)(a) argument, because it doesn't cover the board of if the legal error is established, the way I say it is. So if my lords are with me on the interpretation, then this section 31(2)(a) argument doesn't go to the ground. And because it assumes that the reserved matters approval could have been approved in the absence of condition 13 details and the programme of upgrades, which is wrong. And certainly not highly likely, because I think the point is made, well, they could have approved and breached condition 13 and then gone back under section 73. I certainly don't think it can be considered highly likely that the council would have approved the reserved matters on the outline planning permission, if that's what they thought they were doing, in knowing breach of condition 13. I can't see how that would be highly likely, plainly not rational.
I'm not sure I'm following that, because actually at the time when the reserved matters were approved, they knew there was no solution to the Buckingham water treatment works. But this is where the arguments have to confront reality, which is that at present there is no solution, and that was something the council had to grapple with as part of the planning merits, the factual context of the reserved matters application they had to consider and determine, when they chose to determine it, on the merits at that time. So there's a sense in which the variation, the observation about as varied by, even if that weren't there, that doesn't change the planning merits that the council would have to engage with, because those merits incorporated the knowledge that there was a pickle in relation to, putting it crudely, a pickle in relation to what was happening at the Buckingham water treatment works.
Yes, I don't for a moment shy away from the fact that the officer's report for the reserved matter approval does grapple with, it does talk about condition 13 and indeed these upgrade works. Yeah. So I can't shy away from the fact
the choice for the council was, do we refuse these reserved matters applications because we don't have certainty over the water treatment works off-site, or do we take the view that, notwithstanding that uncertainty, the reserved matters on their face, including the foul water drainage scheme on the plans, is appropriate and can be granted permission?
Indeed, but what they didn't grapple with is the counterfactual scenario that's being posited by the first respondent. So that counterfactual scenario is that they're wrong, and that condition 13 had to be discharged as part of the reserved matters. And if that's the case, they couldn't discharge the reserved matters without breaching condition 13, and they certainly didn't engage with whether it was even open to them to do so.
Yeah.
Thank you.
So ground two then, the core submission here, as my lords would have picked up, is that there is no statutory route to doing what the first and second respondents think they've done. There's no statutory route to allow the switching of a live reserved matters approval application from one planning permission to another. The burden is firmly on respondents to provide a good reason to imply such a power, and they failed to do so. And indeed, with reference to my arguments on section 73 sub 5, there is a positive good reason why the court should not imply such a power. So with that overarching submission in mind, I have just 6 short points on legal propositions, given that we are in a sphere where there's no decided case precisely on this point. Starting from the proposition, which is not in dispute, that the Planning Acts are a comprehensive statutory code. That's in the Pioneer and Fisk cases that I've set out in my Skirson argument. What is that comprehensive statutory code in this case? It comprises sections 92, 73 of the Town and Country Planning Act, and articles 6 and 27 of the Development Management Procedure Order. 2015. Beginning with section 92, the plain wording of section 92, I should take the court to tab 1, page 10 of the authorities bundle.
Yep.
92.1 refers to the relevant development order. So in the section 91 and 91, outline planning permission means planning permission granted in accordance with the development order. That development order is the Development Management Procedure Order 2015, which I'm going to call the DMPO if I may. I've not even given it its full name. It is a very long name. And we'll come to that in a moment. And that describes how the process is intended to work for reserved matters approval and indeed discharge of conditions where you might have a full planning permission. Section 92.2a then relates to the application for approval of reserved matters which must be made, and the word used there is made, not later than 3 years from the date of grant. I think my overarching submission about section 92 is, contrary to what the first respondent says, it doesn't assist a great deal in answering the question that arises on this appeal. The respondent's arguments at 83 to 86 of the first respondent's skeleton argument emphasises the use of the word making, or made, as I highlighted, of the reserved matters approval. But that doesn't really take us very far. If anything, it supports the appellant's contention that what is required for an application for reserved matters approval is that it is made in relation to the planning permission, and the only application made in relation to the planning permissions here was in relation to the outline planning permission. The Development Management Procedure Order is the next provision to go to. That's in the bundle, tab 3. Pages 30 and 31, beginning on page 30. That's Article 6 and the provision for applications for approval of reserved matters. And here we're told it must be made in writing, give sufficient information to enable the authority to identify the outline planning permission. B, must include such particulars and plans and drawings as are necessary to deal with the matters reserved. The same is essentially said in Article 27 about applications to discharge planning conditions in terms of what is required for such an application to be made. And my short submission on the DMPO is this. An application for reserved matters discharge, reserved matters approval or conditions discharge must be made in writing in respect of a grant of planning permission. Whilst you're within the same planning permission, it's understandable that changes may be made to that application as time moves on. There is that scope, as the Inverclyde case illustrates. But once there is a new planning permission, the only sensible reading of the legislation is that Articles 6 and all 27, if they apply, require a new application to be made to discharge the reserved matters or condition. Not least because that new planning permission may have different conditions which may interact differently with one another. This is not a submission that invites the court to put form over substance, but to give primacy to the legislation as its plain wording indicates, which upholds, in my submission, some measure of order and transparency to the process. Then section 73, turning back, I'm afraid, in the bundle to tab 1, beginning on page 3. It's well understood, I think, that Section 73 results in a new planning permission. And that's in the Lambeth case, but I won't go there. The developer must therefore decide which planning permission to implement. Section 73 provides for the variation of conditions subject to the limitation it sets out at 73.5. And that's over the page, on page 4. Rather than reading it out, I might just give my old moment to read it. Subsection 5 then makes clear that the principle of development established by an outline planning permission is subject to an immutable time limit. And the final proposition of law, with reference to the C.G. Fry case that I've referred to in my skeleton argument, is somewhat trite, but it's that a planning authority cannot undermine a condition on which the grant of planning permission was predicated by ignoring it. That's in the C.G. Fry case at paragraph 72. Not proposing to take the court to it. Under ground 2, then, I have 6 submissions. And the first relates to the wording of the legislation. The application was made pursuant to Articles 6 and 27 under the outline planning permission. Applying the plain wording of the Comprehensive Code, the legislation provides no route to switch an application without a new application being made. As that was the form of application made, i.e. under the outline planning permission, that was what the first respondent was bound to consider and determine, unless and until a new such application was made in respect of another planning permission, such as the Section 73. The case law supports this position and does not support the first respondent's position. First, want to take the court to the Power Gen case.
The result thing is they could never get an approval of an application approved for reserve matters under Section 73 permission, because by the time they got it, the time had passed. They were wasting their time.
Indeed.
But they could do it now, presumably.
Well,
They could say discharge the approval of they don't have a condition requiring approval of reserve matters because you've approved them.
Well, no, you could. Well, a variation of that would be to make an application to discharge any compliance with condition 13. Yeah, I mean that would then be for the local authority to determine on the merits. Yeah.
But would they have? I mean, all those other conditions you showed us, which are reserve matters, the siting and the landscaping and things, those haven't been approved under the Section 73, have they?
well,
On your case, or on what I put to you earlier?
on my case,
Or assuming...
on my case, the conditions that are referred to beyond 8 and 22 were discharged. Just they were discharged on a modelled basis. And we say they
my
must
fault,
be
I'm not being
discharged
clear.
under. They thought
There
they
were things that were reserved matters in the OPP,
yes.
and they got a piece of paper which says
Yes.
those have been met, in effect. But they've not got a piece of paper saying those have been met under the Section 73 permission, and it's too late ever to get a piece of paper saying those reserved matters have been met and satisfied, because the time for making the application, the expression of view in the Section 73 permission has gone. The fact they've said the same thing in relation to the OPP, you say it's just a quirk of life. Well, that's your case.
I agree with that entirely. The case law, which, as I've said, does not directly address the point in issue, does support my submission on whether there's the power to do this. The first case to go to is the Power Gen case, which is at tab 7 of the authorities bundle. And if the court could please go to Page 91 of the authority bundle.
Sorry, wait, which page?
Page 91.
Yes.
There were a few other moving parts, but the court at paragraph 33 recounts the submission made to it that to construe section 73 as envisaging the grant of an independently viable permission would produce absurd results. And the absurd result cited there is where details had already been approved under the earlier outline permission. They would need to be submitted and approved afresh. That's the submission that was made. Over the page on page 92, at paragraph 39, that submission is rejected. I'll just let my lords read paragraph 39 in full. Paragraph 39 then expressly is about details already approved. It's about the transfer or the porting over of details already approved under the outline permission to the new planning permission under section 73. It does not address details that have not been approved, conditions that have not been discharged.
So,
and in fact,
tomorrow, the developer could go back to the council and say, I'm applying for variation of conditions, and instead of condition 1, put in a condition that the development should be carried out in accordance with the plans approved under the OPP. That's perfectly possible.
I think that would be possible. But what paragraph 39 makes clear, it says, I just want to draw the attention to the sentence beginning in those cases. It says, in those cases where it does not, there is no difficulty in referring to the old plans. And what's meant there is alteration of conditions involving alterations as to previously approved details. Sometimes it will not. And in my submission, that does make clear that there's a distinction to be drawn between approved details being ported over and details that are not approved being ported over to, conditions that have not been approved, discharge being ported over to a new planning permission, and an authority simply being able to say, well, okay, we're going to consider this under the new planning permission. The other case cited in support of the first respondent's argument is the Hill case in the authorities bundle, and that's at tab 9. And the comments are, forgive me, the bundle pagination is actually invisible because of the way the photocopying was done, and I apologise for that.
Not electronically, it isn't.
Thank goodness. But internal page 268, which is in the top left-hand corner of the page. Paragraph 3. It's said by the first respondents that this assumes that the details under the old planning permission could be ported over. But these comments are I think over to say, and don't really take matters any further than what's said in PowerGen. Then we come to the Lambeth case in the Supreme Court. And that's at tab 16 of the authorities bundle. It's 365 of the authorities bundle, paragraph 12. This is a case which I think the Constitution will be somewhat familiar with.
This is why I got badly wrong.
I think a great deal of my Lord's reasoning was in fact affirmed. But, paragraph 12 states, although the section, this is all about section 73, although the section refers to development in the future, it is not an issue that an application can be made and permission granted retrospectively in relation to development already carried out. And then there's the next sentence. This question arose indirectly in the context of dispute about validity of the time limit condition, which required the development to which this permission relates to be begun within 3 years. The Court of Appeal upheld the inspector's decision that this condition was invalid in circumstances where the relevant development had been carried out many years before. The development to which the section 73 related, in that case, had already been carried out. So the condition, the time limit condition, had effectively been overtaken by events. It had been overtaken by the fact that development had been carried out. We say the logic of that means that in our situation, in this case, where the development hasn't happened and the details have not been approved, section 73 just doesn't work in the way that the second respondent thinks it does. I then want to turn to a submission made by my learned friends for first respondents in their skeleton argument at 53. In my own friend's skeleton argument 53, which is in the bundle, it's page 38, or bundle. The last sentence of 53 states, it says, in other words, the section 73 was granting outline planning permission for development in accordance with the description development under the OPP and any details approved under an application for approval of reserved matters made with reference to that outline permission. But that doesn't reflect the reality of the situation because there weren't details approved at the time of the section 73 permission. So I'll listen to what my own friend says, but it seems that this is a tacit concession that the section 73 was limited in scope to the details that had been approved under the outline planning permission. That would be like the power gen approach. But that's not actually the circumstance that arises here, because of course the details haven't been approved. There's other case law cited by my own friends at paragraph 88 of their skeleton argument, which is said to be underlying, some 45 of the core bundle, said to be underlying principles emerging from the case law. Essentially, Inverclyde, and then this apparently is not a field in which technical rules are appropriate, and then it said the underlying purpose of the power under section 73 is to enable applicants to seek removal without the risk of losing permission. With those high-level principles, I say, don't really assist answering the focused question that arises here. So that's under my first submission on ground 2 in relation to the wording of the legislation, and so far as it assists us, what the case law says. Second submission under ground 2 is the legislative purpose of the relevant provisions also supports the appellant's case. The first respondents say at paragraph 90, their skeleton argument, they say this: the purpose is to allow the local planning authority to preserve permissions where an application has been made in time for approval. That's what's said at 90 sub 1 of the first respondent skeleton. In my submission, that is exactly contrary to the purposes, and that is effectively gaming the system, suggesting, as it does, that once the time limit has been formally complied with, doesn't matter. The permission can effectively be banked for a significant period of time. That can't be taken to be the purpose of that time limit condition. The purpose of that time limit condition is to prevent the accumulation of planning permissions and ensure that details are considered relative to the up-to-date position. That apparent purpose also would undermine the principle of development as established by the Outline Planning Commission. Time limit conditions, in this respect, give effect to and limit the principle of development established by the grant of planning permission, and they are immutable in respect of the reserved matters applications. And therefore they ensure Section 92 and indeed time limit conditions that go within Section 92 ensures that permissions are not banked in this way, and that details come forward in a reasonable time, and that changed circumstances can be taken into account. That is illustrated by the reasons given for condition 2 in this case, which say essentially that. Thirdly, respondent's approach would allow a formally valid, so made within time, but incomplete reserved matters application to pass the test, rather than all the necessary details being provided at the time the application is made, which is clearly what the legislation anticipates. So that's the...
So you say, do you, that it wasn't open to the planning authority, in this case, to consider the application for approval, avoid using the phrase reserved matters, but impose additional conditions?
No.
It wasn't open to.
No, that's not what I'm suggesting.
But you just said that everything had to be complete.
No, just speaking in broad terms about the purpose of the time limit conditions is that a submission is made not merely on a sort of skeletal basis, but the details. And I accept, in this case, there were amendments and new documents provided after that deadline that we don't take an issue with. Of course I do.
No, that's not the question I'm asking you. They had to provide details of electric car charging points and all the rest of it, and they provided some details, but not all that which the planning authority wanted to see. So the planning authority said, well, what you provided so far, that's good as far as it goes, but we need more. Now, you, as I understood the submission you've just made, that is not a valid application within the time limit because it wasn't complete.
No, that's not. If that's what I was taken to say, that's not what I intended.
Right. What are you saying?
I'm responding to the purpose argument that's
right.
mounted by the first respondent, and the purpose that they say is served is that once the time limit has been complied with, then details can be submitted, and that's essentially the purpose of the legislation. Is to allow a developer to, what I would say, perhaps pejoratively, to bank permission. I'd say that's simplistic and not right. So my submission only needs to go that far.
Why is it not right?
Because the purpose of the time limit condition is to place a limitation on when details can be submitted.
But that timescale is measured not by when it's granted, but when it's submitted.
Correct.
So it's a necessary evil within the system that applications can be made in time and then can take many years before they are actually approved, but they are nonetheless applications that are valid.
They are.
And their validity is tested at the time when they're submitted against the procedure order as to whether they have all of the necessary details to be properly validated by the council.
That's right.
Yeah.
That's right.
You've got an analogous situation when in terms of when development begins. People dig a couple of trenches, keep the planning permission alive.
Indeed, that is perhaps true, but it doesn't mean that is the purpose of the legislation itself.
No, but it might suggest that the purpose of the legislation is not to stop those kinds of things happening. It's not intended to be a bar. We don't want planning permission, you never get it, and we put all these restrictions in to stop it. It may just be a structured system trying to make sure that proper decisions are taken at appropriate times.
I accept that. So, moving on, if I may, from that point to the third submission under ground 2, which is that, which is again part of the purpose of the legislation topic, and this relates to section 73 sub 5, which we've looked at. 73 5b says a planning authority cannot grant planning permission to the extent it has effect to change a condition subject to which a previous permission was granted by extending time within which the application for approval reserve matters was to be made. The appellant has, we've never sought to argue that the present decision formally extended the time limit condition in that way and so directly breached section 73.5. Our argument is that what's taken place effectively circumvents what Section 73(5) is seeking to protect. It had the effect of doing so, and one does not need to breach a particular statutory provision in order to act contrary to its purpose, to undermine it. There's no authority for the proposition advanced by the first respondent that restrictions at sub 5 can be lawfully circumvented, whereas here the expiry of the time limit has taken place, and the developer obtains a new permission under Section 73 with different conditions to those on the original outline planning permission, and then seeks to switch its reserved matters approval application to that permission to effectively, as I put it colloquially, move the goalposts. As a matter of principle, that must be wrong. Were it permissible, it would undermine the force of Section 73(5), allowing a developer to move the parameters of the application to which the reserved matters time limit applies, and so underline that time limit. It would allow, as I said, the permission, the outline permission, to be kept alive because a reserved matters application has been made, but then a Section 73 to effectively roll forward the outline planning permission and the details required under it after the deadline, after the cut-off deadline, which we're told can't be changed. And that is a part of the respondent's decision, and indeed case, that does have wide-reaching consequences because it is a device. It is a device that would have consequences for other cases where, perhaps on similar or different facts, but where a developer had reached a similar point in time where they'd gone past the time limit. The fourth submission then is that my submissions on this do not give rise to absurdity, as is said by the first respondent, and I think this in some senses is the high point of their case, because they say at 92 of the skeleton argument that there is absurdity that once the time limit has expired but before conditions discharged, the scope to vary the conditions is... Sorry, they say, perhaps go, but rather than try to paraphrase what they say, if I take the court to paragraph 92, well own friend skeleton argument, that's on page 47 of the core bundle. And here they say this, that on the appellant's interpretation, either one, there is an anomaly, because applications can't be made under Section 73 once the reserved matters time limit has expired. Well, that's fine, but that's not our case. Mm-hmm. And secondly, they say, well, the order in which applications are made or even determined is to be decisive as to the legality of the approval. And that, I think, is the high point of their absurdity argument. But that's not our case, and that's not right. The point made is that it's not the case that the order of events is arbitrary or meaningless. It is here important because the outline planning permission requires the making of an application within a certain period of time. It makes a nonsense of this if it is just a formal requirement and you can then come back and then effectively amend the outline planning permission without having to examine the principle developed again. And the order in which things take place is often important in planning, and it is here. It may often secure important interests, and here the interest that development is proceeded with within the time limits envisaged, and that it is detailed considered in relation to up-to-date criteria. And the development ultimately comes forward in a reasonable time from the principle of development being established. On the appellant's logic, before the expiry of the deadline for reserved matters approval, you can get a Section 73, but you would then need to apply for a new reserved matters approval under that Section 73. That flows both from the wording of the legislation and indeed common sense.
But if you've already got an approval of reserved matters on the original planning permission,
yes,
the suggestion from PowerGen is that the developer can simply say, well, I'm going to implement my Section 73 application reliant upon those reserved matters I've got approved under the outline planning permission.
Yes, and I completely agree with that.
I think that's the point that's being made.
Yeah.
And so that is why is there any magic in the order in which you do these things, bearing in mind there is built into the system the opportunity for there to be slack between a validly made application and the approval of that validly made application at some later point in time.
Yeah, that's right, in that there is a difference. There is obviously a difference in the case law, because power gen only goes as far as our case, which is that after the approval of those details, then a Section 73 can be used. But in the circumstances that we have here, the reason...
Why does it matter that the Section 73 application can only be made after you've got the reserved matters approval? Why not in anticipation of the reserved matters that you've already submitted being approved? Can you not make a Section 73 application with the intention of subsequently saying, I'm now going to apply those reserved matters to the Section 73 that has now been granted to me?
It does create great uncertainty, because the position in our case is that the conditions are not discharged. So there's not. So
well, that breaks back to your
Planning
implementation
Commission
point, your interpretation point.
The Outline Planning Commission has not, not only has it not been commenced, but it's not crystallised to the extent that the details under it have not been submitted. It's not been demonstrated that can be done necessarily. In the same
well, that's
way,
an objection to the Section 73 application, isn't it? That's an objection that says you shouldn't allow the Planning Permission to be approved without Condition 13, because on the merits, it's inappropriate. But if you accept that the Section 73 application has merit and should be granted, why does it matter if it's approved prior to the approval of a validly made TMS application for reserved matters or after it?
Because the parameters have changed from the application as it was originally made in respect of the Outline Planning Permission to the Section 73. And the principle of development is established in the Outline Planning Permission with reference to the conditions there imposed and the time limit. And that protects an important interest. So the limit to our argument is that you can't vary the condition after the deadline, effectively, where the discharge of it is still outstanding. And that's as far as the argument goes, as far as the argument needs to go. Fifthly, I addressed the submission made by my learned friends about established practice or settled practice. They say in 94 of their skeleton argument, I think it said that settled practice is capable of being relevant to the interpretation of legislation. In my submission, that goes nowhere, because they haven't established what's needed to be established for that statutory interpretation principle to come into play, which is that you need to have ambiguity in the statutory provision. In any event, even if they had established there was ambiguity, they haven't established settled practice. They've cited a previous decision from the same local planning authority and a letter from Carter Jonas, the planning consultants. So that's, just for my Lord's reference, the ZH and CN case from the Supreme Court is what's cited in support of their arguments, and that's tab 11 of the authorities bundle. And my Lords will see it, paragraph 53 essentially says settled practice is relevant where there's ambiguity. They've not established that there's ambiguity, and they've not established that it's settled practice. Sixthly, and this perhaps comes back, give me my Lord.
It's also where, I mean, I'm just looking at it very quickly. It sounded shocking to me when you said it, because lots of people up the land might read the Act of Parliament and think, oh, that's what I've got to do. But if they were told in Cornwall, oh, no, look what's been going on in Northumberland for years. But this says that where Parliament has reenacted certain things, then you can look at the way in which it had been reenacted previously, because Parliament will have made a choice that by using the same words, knowing that those words have been understood to mean certain things, that's what they mean. So it's a bit more nuanced than if Cornwall has been doing it, Northumberland must go with it.
So it's even more of a high bar than I put it as. I'm grateful. Sixthly, under ground 2, is that, and I think this goes back to the discussion we were having in between grounds 1 and ground 2 submissions, there's no basis for a hybrid approach whereby a reserved matters decision purports to discharge reserved matters and conditions on a combination of 2 planning permissions. And that makes a mockery of the fact that the second is supposed to be an independently viable planning permission, and that a developer has to choose which to implement. It would make it wholly unclear, to the public at least, which planning permission is being taken. Yet that is, in fact, in reading the decision notice, there's no easy, it doesn't make for any easy reading. because either one reads it as having been amended under Section 70, having been amended to reflect Section 73, for which there's no power, as I've said, or it's under the Outline Planning Commission and has left out important factors, or it's a hybrid approach for which there's no authority, no logical basis. So issue 5 I can take very briefly, which is essentially whether on the fact of this case, this is on the ground 2 still, this could be done. And my short submission is it's wrong as a matter of principle in this circumstance for the reasons that I've given already. In terms of the Section 73(5) point, here the grant of the application did have the effect of overriding or altering the time condition, subject to which the outline permission was made, because it allowed an application to be considered as if it had been made in relation to the Section 73 permission after the deadline for making the reserved matters applications on the OPP.
Sorry, just clarify for me that you, under ground 2, when you opened this appeal, you said there were 2 points. The first was whether a live application for approval of reserved matters could be switched from one planning permission to another. And that you dealt with. You say it can't be done as a matter of law. And the second question that you posed was it done here? But isn't that answered by the decision notice? It wasn't.
Well, I agree with my lords that it wasn't, because it can't be done. It's slightly circular.
Well, whether it could or couldn't be done, it wasn't.
It wasn't done. No, and that the reference to the Section 73 permission doesn't really take us anywhere. But
well, on that analysis, it's not that the reference to the Section 73 application, as my Lord Justice Lewis said, may be in some respects, a complete red herring. However, the fact that that permission had been granted was a feature, may or may not be of very great weight, but it was a feature in the determination of the reserved matters and the planning merits for determining the reserved matters, if predicated on the assumption they were reserved matters under the original outline.
Yes, and it was a feature, but it doesn't mean. But it was a feature, but the basis on which the local planning authority made the decision was an erroneous one. And although Condition 13 was discussed in the officer's report, that there wasn't a consideration given, it seems, to imposing a further condition on the reserved matters to allow for Condition 13 under the Outline Planning Commission to be dealt with at a later date, if indeed I'm wrong on interpretation.
What the local authority did doesn't depend upon what they thought they were doing. It depends upon what the public document says.
That's right. That's right. I mean, I agree with that. I think my response is that it's evident from the document that that's what they thought they were doing. Slightly circular.
No, it's not. You've got to read the document. You only know what they were doing by reading the document, ultimately.
Yeah.
It's objective. Otherwise, you need to interrogate every councillor and every person in the office who signed the planning permission, because you've got a corporate body and officers giving effect to it. You can only operate by looking at what they said. Like Parliament. Yeah. Goodness knows what they mean, but you look at the words.
Yeah. I'm grateful for that, and I completely agree. This fifth issue, which is the sort of second part of ground 2, is simply to make good that on the facts of this case, in my submission, I agree with my Lord's indication at least, that there was not a switching, but that was not the basis that the decision notice suggests they thought they were deciding it on. So the decision notice was based on a flawed assumption. And if it had been what they were doing lawfully, then it's one that was not open to them under the legislation. On discretion on ground 2, my response is essentially the same as under ground 1, which is that this all relies on the same flawed counterfactual, which is that the first respondent would grant the reserved matters application despite the lack of detail on Condition 13. And that despite the legal error, would have necessarily come to the same conclusion. We can't draw that conclusion, particularly in circumstances where there was no discussion of imposing a further condition on the reserved matters to require Condition 13 to come forward under that. Granting in the face of a breach of Condition 13, as I said, is not something they grappled with, certainly not highly likely. I want to then deal briefly with the further points made by the second respondent in the time I have available. So in the second respondent skeleton argument at paragraph 8, there's reference to the brand new provision that came into force today, which is section 92A of the Town and Country Planning Act, inserted by section 56 of the Planning and Infrastructure Act 2025. I'm not entirely sure, other than bringing it to the court's attention, what the second respondent intends to say about this. But I do feel it's important to make clear that transitional provisions mean at the moment the extension provisions don't apply unless there's a relevant event that's occurred after the commencement date, so that would be after today.
So does this apply to this case or not?
It doesn't apply to this case. It would apply if there was an appeal, a permission to appeal to the Supreme Court granted.
Oh,
it would be triggered by that. But that's the only, in terms of this case. But that's obviously not the position we're in. So far as leave has been granted to bring the judicial review and to come to this court, those events took place prior to the commencement date, which is today, and so it doesn't have any effect. As I said, I don't know if that's actually in dispute, but just to bring that to the court's attention. And that's why my learned friends with first respondent helpfully suggested that we give to your lordships a copy of section 56.
You have a right of reply.
The further point that's made by the second respondent is at 41 of its skeleton argument. Here it is said that ground 2 is parasitic on ground 1, and that if the reserved matters application was lawfully amended under the Inverclyde principle, then ground 2 falls away entirely. And our response is that that's just entirely wrong, because ground 2 is concerned with a separate vires question, effectively. Ground 1 is, as I accept, going to ultimately come down to whether a judgment made as to the change to the application, the court's with me, that there was a change to the application, was a reasonable judgment. So they are different heads and different challenges, and the second is not parasitic on the first.
Yes.
That does bring me to the end of my submissions on the grounds, unless I can give further assistance.
Thank you very much. Yes, Mr. Street.
Yes, my lord. My case rests on two alternative submissions. The primary submission is that the local authority had the power to grant a Section 73 permission, which envisaged that reserved matters may be approved pursuant to an outstanding application for approval of reserved matters made in respect of a parent outline permission, and to approve those reserved matters with the effect of discharging the requirement for reserved matters approval under the Section 73 permission. That I will make good under ground 2, but that's my submission on the statutory scheme. My alternative submission is that even if I'm wrong about that, the local authority certainly had the power to achieve the result that it believed it had achieved, and in those circumstances, relief should be refused under Section 31(2)(a) of the CE.
What do you mean by result?
The grant of a permission which did not have on it the first half of Condition 13, so which was not subject to the requirement to comply with the first part of Condition 13, but which otherwise required the development to be in accordance with the details approved pursuant to reserved matters approval.
But if you had the power to achieve that, then you go off and do it. You ought to use discretion, which normally means you don't quash something that's been granted, to turn it into something that it isn't what was granted, because you could have done something else.
Well, my lord, the point that I will make when I come to this is that if the local authority did things in the wrong order, it's highly likely that the outcome would not have been substantially different had it done things in the right order.
Wouldn't the better approach to life in this case be to see what was done and then to see what the consequences are, rather than saying, what I want to do is get to the moon, so it doesn't really matter if I've booked a flight to Prague. Treat it as if it's a flight to the moon, which is what we seem to be.
No, my lord, I accept that, and I can tell you that my note has construction of permission and then consequences of construction in the margin, so I plan to do it that way.
And the decision.
Yeah, yes, my lord, I plan to do it in exactly that way. I'll take the grounds in turn. And I'll start with ground 1, which I deal with in my skeleton for your note at paragraphs 56 to 78. As pleaded, it has 2 analytically distinct limbs. One alleges a breach by way of misinterpretation of the Outline Planning Permission, and the other alleges that the judge was wrong to conclude that there was no substantial alteration to the reserved matters approval, as the reserved matters application made. And I do say that those are different things with different consequences, and I propose to take them in turn. Dealing then with the first of those, the construction of the outline consent. If we turn that up, it's in the supplemental bundle, tab 1, page 5. And my submissions on the construction of the document are in my skeleton at 44 to 50. But in essence, my submission is that on a proper construction of the Outline Planning Permission, drainage is not a reserved matter, and the submission of a foul water drainage scheme was not subject to the 18-month requirement under Condition 2. Rather, the combined effect of Conditions 1 and 13, read together, was to impose a pre-commencement requirement for the submission and approval of a foul water drainage scheme. And I say that is what the reasonable reader of this document, equipped with some knowledge of planning law and practice, would understand the words used to mean when read in context. Before I make that good with reference to the document itself, I would just like to turn up the decision of Mr. Justice Burton in Murray, which is in the Authorities tab 8, page 94.
Can I just ask this? The foul water provision included, for instance, ponds, which we see on plan. Would they not have been appearance or landscaping or layout? I mean, in other words, is there not some degree of overlap between what are reserved matters, as defined in the legislation, and as Mr. Justice Burton held, and the foul water provision? Isn't there some overlap between the two?
There is overlap. I'm not disputing that there is overlap, but that does not render Condition 13 and what it refers to a reserved matter.
No, I'm not suggesting that necessarily that it does, but all I'm asking is whether you can treat the whole of Condition 13 as hermetically sealed from the reserved matters.
I think it's a practical question rather than a construction question. In practical terms, your reserved matters that you get approval for will need to be capable of being implemented in a way that allows you to comply with Condition 13.
No, it's the other way around. If you've got approval for reserved matters which shows no ponds, but the foul drainage scheme you want has ponds, then you can't do it.
Yeah.
Because you've got to do it with 13. It's the other way around from the way you said it.
I agree with the way that my lord has put it. I didn't mean to put it the wrong way round. And that could get you into trouble. If you've got that reserved matters approval and it's not possible to do the drainage in the way that you want it consistent with that, and you're out of time to make an application for reserved matters approval, then you will be stuck.
It limits your ability to do the things in 13.1, or it could limit.
It could limit your ability to do it, but that does not mean that as a matter of construction of the document, you need to comply with Condition 2 when you are making an application.
So in other words, the reserved matters that you put forward for approval should, at least in an ideal world, be compatible with what you envisage in order to discharge Condition 13.
Quite right.
Even absent Condition 13, if you produced reserved matters which didn't deal with the obvious issues, you'd be liable to have them refused, wouldn't you?
One, you'd be liable to have them refused, and two, if you got approval for them and then a subsequent issue arose, you'd be stuck because you can't make a new application.
Yeah.
So yes, I mean, as I say, I think it is a practical issue and one which planners are well familiar with when they frame their application for approval of reserved matters. But, my Lord, where I wanted to go in terms of the background to reading this consent was the decision in Murray, which is Authorities tab 8. And, my Lord, starting on what I believe to be page 96,225 of the report. And the paragraphs I want to rely on are 12 to 14 first, which are on page 227 of the report. The issue, as crystallised, was whether an application for the approval of a scheme for the provision and management of alternative grassland secured by condition was a reserved matter and subject to the time limit for approval of reserved matters under section 92. My Lord will see that most clearly from paragraphs 14 and 15. And then going on, paragraphs 20 to 24 make clear that the definition of reserved matters is exhaustive and that a condition on an outline permission providing for subsequent approval of, amongst other things, drainage is not a reserved matter. That's said in terms in paragraph 24. And then paragraphs 33 to 35 on 231 of the report. Approvals of reserved matters are therefore governed by the time limit in section 92(2)(a). Other approvals under an outline permission are governed by the time limit in section 91. But this was a specific point. How do the time limits interrelate? Decided at paragraph 35 by Mr. Justice Burton. And I do say that that distinction falls within the scope of the knowledge of planning law and practice which the reasonable reader is to have imputed to him. He will understand that that is the way.
The decision in this case is that the phrase in section 92, in accordance with the provisions of a development order, mean as defined by a development order.
Yes. And that in consequence of that, the time limit for submission of approval of reserved matters, as defined in the development order, everything else is dealt with under the general time limit under section 91, i.e. pre-commencement. And I do say that's important because when someone's reading this, they will read the document knowing that that is the usual way in which this is done. And so if we turn to the permission itself, it says on its face in the description it's an outline permission with all matters reserved except for access.
Sorry, where are we now?
So page 5 of the supplemental bundle.
Yeah.
And its number at the top, is that like its name?
Yes, that is the reference number that you would find on any advice from a lawyer about it.
Right. And if I was a member of the public wanting to look up a planning permission,
You'd put
that's
that in.
what I put into the Local Authority Planning Permission website.
Yes.
If I was a Law Justice Dove electronic person, or I would look for that if I was a Law Justice Lewis Dove.
Yes.
Or, yeah.
My lord, and the
You
effect.
wouldn't find a file.
No, right.
What my lord would find.
That is the thing that identifies that planning permission.
Yes.
That's its name.
Yes, and that is what would bring you to the planning register, which the development management procedure order requires all the relevant documents to be added to. In practice, that is online nowadays.
Will the 73 permission have a different name?
It does have a different reference number, but they would be linked on that file.
But by and large, on a planning register, it's configured by searching via land, and a parcel of land will have the planning history of all the various
It will have
permissions.
all of the applications, so there'll be documents associated with an application and documents associated with an area of land, and documents associated with an application will come up under the application reference, and documents associated with an area of land will come up using the postcode or the grid reference, whichever one prefers.
Anyway, this permission is called 16000151 AOP. Yeah.
Yes, and AOP is outline permission,
Yeah.
I believe. Yes. So just reading it, the first point I wanted to make is that it's all matters reserved except for access. And then when one turns to condition 1, the other reserved matters, in the order they are referred to in the DMPO, are set out and defined as the reserved matters. And so it's appearance, landscape, layout, and scale that is being referred to when we see the words reserved matters. What condition 1 then requires is details of those matters to be submitted and approved in writing by the local authority before development begins, i.e. that is a pre-commencement condition, and the reason given is that it's an outline application. Condition 2 then requires an application for approval of reserved matters to be made to the local authority within 18 months of the permission. And when we read that in the knowledge of the definition that we had under condition 1. But that doesn't mean that we're tying everything under condition 1 into this. It just means that the application for approval of the reserved matters must be made no later than 18 months. And we read that in the context of the reason given, which is expressly to comply with the provisions of section 92.2. And that's why I took the court to Murray, because when you read this, you'll read it knowing that this is the usual way and that this is the condition being imposed to comply with the obligation under the legislation, and it concerns only the reserved matters as defined in the DMPO. This sets a separate and specific time limit for the making of the application, which is different from the general submission and approval in writing under condition 1. And I just note that there's a difference in language, submission under 1 and application for approval under 2. The words application for approval reflect the language of the primary legislation in section 92.2a. So I do say it's as plain could be that what is intended by this is simply to deal with the statutory obligation for the reserved matters and the reserved matters alone. Condition 13 on page 8 then deals with details to be submitted for approval in writing in accordance with condition 1 for foul water drainage, and then it specifies what that should include. It does not say that there should be an application for approval in accordance with the time limit in condition 2. It could have said that, and it doesn't. It, to use my learned friend's word, ties it only to condition 1. And so in my submission, I prefer to use the language of a cross-reference. The cross-reference that we find in condition 13 is only to condition 1, and the requirement in condition 13 is for submission and approval of that information pre-commencement.
And submission is the word which is used again in condition 13.
Precisely, my lord. So I do say that the judge was entirely correct at paragraph 121 of her judgment to conclude that the 18-month time limit for applications for approval of reserved matters applied only to reserved matters as properly defined in the DMPO. And to be clear, as will have been apparent from paragraph 4 of my respondent's notice, which for your note is Core Bundle 11, page 131, we don't need the reasoning in paragraph 118 of the judgment to get there, which is the in accordance with gloss. That is not relevant to the correctness of the judge's overall conclusion.
I mean, the problem with the gloss is it would have no time limit at all. Would it?
Well, I'm not sure that is actually right, because it would still be subject, at the very least, to a deemed condition under section 92 and or section 91, and we put a note in specifically on that. So I don't think it would mean no time limit at all. It would still be pre-commencement, and then the date for commencement would be the date by which the by which development has to be begun under the permission. So it wouldn't be no time limit at all. But I do not adopt the gloss.
No.
It is not relevant to the correctness of the conclusion, which is an issue.
Looking at 13.1, first sentence and second sentence, there's a difference. The details to be submitted for approval in writing in accordance with condition 1 above. We know that's appearance, landscaping, layout and scale.
Yeah.
Submissions on those 4 matters shall include a foul water drainage scheme for the site. To give that meaning must be, I think, that when you're doing appearance, landscaping, layout and scale, they must show how the appearance of the site is going to be affected by the foul water drainage scheme.
Yes, I'd accept
Not
that.
because you need the foul water drainage scheme to be approved as a reserved matter, but insofar as it's related to appearance, it's got to be included in that application.
Yes, correct, and that comes back to the point my Lord Justice Lewison made to me earlier.
Then you go to the second sentence, and that's different. Within that thing, the scheme, is another thing, an assessment of wastewater treatment capacity, and that's looking outside. That's looking at the water station to see if it can accommodate it. And then there's a third thing. Will that need infrastructure upgrades? Do you need another water station? Do you need bigger pipes? I don't know. And then the fourth thing is a program for carrying out the works. Now that may affect the infrastructure, but it may also involve doing work on the site itself. I don't know, laying bigger pipes or putting in some new junction. I don't know anything about plumbing. But there are four things there, some of which will have to be in the approved reserve matters, and other things which don't have to be. And also an assessment of things outside the site, an assessment of infrastructure upgrades, and a program for carrying out works, which may or may not affect the site. Is that fair?
Yes, all tied to condition 1.
Yeah.
Yes, and they all have their own different assessments associated with them. So the infrastructure requirement, as my Lord Justice Dove said, will turn on the capacity, and the capacity will be the result of the numbers.
Yeah.
And I mean, essentially, what you need is processing capacity. So if people produce waste, you need a way to deal with the waste. Otherwise, you get storm overflows or non-storm overflows where you discharge untreated waste into the watercourse, which is what I
The
believe.
one thing I do know is that before this is commenced, I will be able to find a document called a program, and that program will tell me what works have to be carried out.
As approved under the outline permission, yes.
Yeah.
Obviously,
So, yeah.
Sorry, my Lord.
So that is a condition, leave aside any reserve matters. Within the period before the development commences, I will, in order for this development to be proceeding lawfully, be able to find a document which shows me the programme of works.
Yes, and that is the requirement which is removed
Yeah.
by the Section 73, because the necessity of doing that is a matter which is revisited by the local planning
It's
authority.
removed
like-
from the Section 73 permission,
Yes.
if that's what you're relying upon as justifying the building of the houses. It's not removed from the OPP.
No. Absolutely right, my Lord. I adopt that analysis.
So another way of looking at condition 13 is to say that the reasonable reader would look at it as addressing both, firstly, on-site and then off-site requirements arising from foul water disposal. Insofar as there are on-site requirements, the reserve matters application should address them, and so far as they are off-site, they remain to be or they need to be addressed by the capacity of the Buckingham water treatment works and what upgrades are required.
Yes, my Lord. I think the way I would put it is, insofar as matters of appearance, landscape, layout, or scale are influenced by the matters in condition 13, then they will have to. Then the reserve matters will have to address them, not as a matter of construction, but as a matter of reality.
Yes.
And in light of the way the conditions are framed.
Yeah.
So, my Lord, those are my submissions on the construction of the outline permission. Just in terms of consequences, if I'm right on the construction, then ground 1.1 fails for that reason alone. There was no material error in relation to the interpretation of the permission. If I'm wrong, then I need to address the consequences of the appellant's construction for the decision under challenge, which is dealt with in my skeleton at paragraphs 102 to 104. But my essential submission is that even if my learned friend were correct, the local authority would still have granted the reserve matters approval, and I make that good
For what? The reserve matters approval for what? The outline planning permission?
under the outline planning permission for the matters as submitted. And I make that submission for the following reasons. Firstly, on my learned friend's construction, drainage still would not be a reserve matter. It simply is not capable in law of being 1C Murray. Rather, there would have been a breach of condition 13 from September 2023 onwards, i.e. from the 18 months. So if my learned friend is right, and you have to submit this under condition 2, then the breach is as soon as the 18-month period expires. So that was historic on 24th of September 2023. My learned friend says that would have been relevant to a decision to approve reserve matters, and he relies on CG Fry. He didn't take you there, and I think I would like to take you there. That is in the Authorities Bundle, tab 27, page 663. And it's paragraphs 71 and 72 he relies on.
Just give me the reference again.
663, tab 27. And if I could just ask the court to read 71 to 72, please.
It's the sentence at 72C, which I think is particularly relied on. Planning authority could not undermine a condition on which the permission it had granted was predicated by ignoring it. Seems to be the principle that Mr. Welch wants to get out.
Yes, but the context for that statement, which is why I asked the court to read the passage, is the decision of the deputy judge in Whiteside, in which what was said was that the breach of one condition was a relevant material consideration in determining whether to grant approval under another. In that case, it was levels, so essentially the levels were not consistent with the accessibility requirements. And the point that I want to make is that, as we see from this, in Whiteside, that point was ultimately not determinative, because relief was refused on the basis that the result would have been the same. In other words, if the breach of condition wouldn't have made a difference to the outcome, then that's not a reason to refuse to grant approval or to approve matters under a condition. And my submission is that we know in this case that the breach of condition would not have been a reason to refuse reserve matters, because the breach which my learned friend is referring to is the matter which was firstly addressed by the Section 73 Commission, and secondly recognised, as my learned friend accepted, in the officer's report. And I do...
Sorry, that's not clear to me at the moment.
Sorry, my lord.
Your argument is, if the appellant is correct, there would have been a breach by failing to submit the foul drainage scheme as defined in 13 by the relevant date. And you're saying that would not be a reason for failing to refuse the approval of reserve matters.
Yes.
Because, it's the because I haven't understood.
Because the local authority regard non-compliance with that aspect of condition 13 as acceptable, and have made that clear through the Section 73 consent they have granted. And I just pause to note the way in which my Lord Justice Lewison describes the purpose of Section 73 in the Finney case. We don't need to turn it up, but for your note, it's paragraph 42. It's as a means of giving a developer relief from a condition and thereby avoiding a breach under Section 171A. That is what my Lord Justice Lewison says is the point in being able to vary a condition. And here, the local authority has granted relief from that aspect of the condition which it said was breached, because it did not regard it as necessary to require compliance with it. Those are the reasons given in the officer's report for the Section 73 permission. We can turn them up if it would help.
I mean, according to what Lord Sales says in C.G. Fry,
Yes, my lord.
Whiteside involved the approval of a plan discharging condition 18, which was inconsistent with a different condition.
Yeah.
Here, at its highest, there was an incomplete submission
Yes.
relating to condition 13, but I don't think it's said, or at least if it is said, I don't see it, that there is inconsistency between one condition and another.
My lord, I agree, and I just add that even in Whiteside, where there was inconsistency, the court upheld the
Yeah.
consent, notwithstanding the inconsistency. But we don't even have inconsistency here. So I do say that this point essentially goes nowhere. I say I'm right on the construction of the condition, but even if I'm not, I say that it doesn't make any substantive difference to the decision which was taken and is challenged in these proceedings.
Yes.
So those are my submissions on ground 1, limb 1. I'm conscious it's 7 minutes to. I can start ground 1, limb
Yes.
2 now. This is in my skeleton at paragraphs 56 to 70. And it is the allegation that the judge was wrong to find that there was no substantial change to the reserved matters application. Now, I propose to address the submission in my learned friend's skeleton at paragraphs 45 to 46, that determining the reserved matters application with the effect of granting approval under the section 73 was unlawful under ground 2. I think that that is the more logical place for me to do that. So here, I just want to focus on whether the reserved matters application was unlawfully amended by removing an application for the approval of details under condition 13 from the scope. And that's in my skeleton 27 to my learned friend's skeleton 27 to 33 and 36.
Again, I'm really sorry about this, but I think it's quite important to understand. Sometimes it seems a substantial alteration that the appellant is complaining about is the fact that the approval should only relate to the OPP, but it's understood or is said to be relating to section 73. Now, if in fact the approval of reserved matters is only in relation to the OPP, then my initial reaction is then there can't have been any substantial variation.
No.
So what is it that you are arguing about? Are you really trying to say this is a section 73 approval, or are you accepting that the decision that is under challenge is a decision granting approval of reserved matters for the purposes of implementing the OPP?
So this is ground 2, and I think this is very important. My submission is that it is lawful to grant a section 73 permission which envisages approval made pursuant to an application under a previous outline condition. And if...
Hold on.
Sorry, my lord.
Lawful to grant a 73 permission which envisages, say that again?
Approval of reserved matters.
Being sufficient for the purposes of the 73 permission.
Yeah, pursuant to an application made in time under a previous outline permission. So the application is made under the outline, but the effect of the approval is to discharge the requirements of both.
No, that's not what the case is about. You're saying it would be lawful to do that.
Yes,
The first question, could you ever do it?
I'm saying it would be lawful to do that, and that's what
Yes,
was done.
you're saying two things. You're saying it would be lawful, so don't worry that we've done it. And you're saying that's what we've done. But in order to know what you've done, you've got to look at what you've done first and then see whether it's lawful. You can't say, because I could do this, I must have done it.
No, I completely agree, and that will be where I go underground too. The narrow issue I just wanted to address was whether, as a matter of fact, there was a substantial change. That was my learned friend's ground 1, 2, by removing something from the application which was in there at the time of submission and came out later. And my short answer is nothing was removed. It was in any event a question.
That's a question of fact.
It was a question of fact. And that's why I gave you the references in my learned friend's skeleton, because he does seek to challenge a finding of fact made by the judge. there's appellate authority to the effect that it's a finding of fact, and there's no reason to interfere with that finding of fact. Those are my very short submissions on ground 1, 2.
Well, what do you say was going on in the schedule that we were shown this morning, where there is an indication in the schedule on the left-hand side that there has been compliance, and then a description?
Yes, so perhaps we could turn up that schedule, and it's page 194 of the supplementary bundle, because the first point to make...
Hold on. There's a sort of rag rating next to the left-hand side.
Yes, so the first point I wanted to make is that the word compliance doesn't mean compliance with this condition has been achieved. It's a categorisation of types of condition.
How? Yeah.
I will make that good. Firstly, before I go to another document, if I could just ask my lords to note the other types of condition in the left-hand edge. So there's pre-commencement type of condition and preoccupation type of condition. And then compliance is a type of condition. And then at 23, there's other trigger.
Yeah.
And to make good that this is a reference to a type of condition, if we could look in the officer's report for the reserve matters approval application. My learned friend did take you here, but at page 99.
Before we go to the officer's report, is this part of the application?
No.
So what is this then? This is the letter that somebody's produced,
It's
and it's of interest, but no more.
It's a document submitted by the developer, which did not form part of the document submitted for approval, and which was not approved in the decision notice. That's page 444 for your note of the core bundle. So that the local authority, I think, could keep track of what was going on with the different conditions. I think that's
memoir then.
Yes, I think that's the purpose of the document. The officer's report, if we look on page 99, just to take one example, paragraph 5.196 says this is a compliance condition.
Hold
It's easier to turn things up if you're working from paper.
I apologise. I'm afraid I'm with the dinosaurs.
Which one?
So if you look at 5.196 as an example, this is a compliance condition. And you'll see that language is repeated throughout the analysis here. 5.206, this is a compliance condition. 5.208, this.
What does it mean?
Yeah.
I think it means a condition with which ongoing compliance will be required.
Good gosh.
And the point I make is that the document, the conditions compliance table, is not a forensically useful document. It's not an application document. It's not suggesting there was compliance with that condition. And the substance of what we find in the right-hand box is, one, erroneous, if what is meant by a foul water drainage scheme has been submitted is a full foul water drainage scheme rather than plans which show some pipes. And two, certainly doesn't suggest full compliance with condition 13, because the second sentence goes on to say what there isn't, namely the water treatment capacity assessment, which is what condition 13 envisages. So, to the extent that my learned friend hangs a case that the judge made a rationally insupportable finding of fact on this document, in my submission he's going to face a very steep uphill struggle.
Right. So it's the right-hand bit that's important, and it's not important at all because it's just what somebody in the authority, somebody in your people,
What the developer
yes.
submitted to the
And
local
what that
authority.
says is something called a foul water drainage scheme has been submitted, and by that I assume something showing where pipes would go from the houses to the system.
The only thing it could be is the plan you've had.
Is
the plan that I handed up earlier,
Yeah, okay.
the A3.
And the other bits in the second sentence of 13.1, it's recognising that those haven't been submitted. That's all it does.
That's all it does.
So it says there are pipes on the plan, but we don't know anything about the water supply station.
Yeah.
Just one other point before we break, if I may, Mr. Streeton. You said that the question whether there had been a substantial alteration was a question of fact for the judge.
Yes.
I think Mr. Welsh said it was a question of planning judgment for the planning authority, which could only be upset on Wednesday principles. That would suggest that it wasn't a finding of fact for the judge. But
So
the question for the judge was whether the planning authority was wrong.
I will answer the question directly and then deal with my learned friend's point. There is binding authority in Tesco and Norfolk, Authorities Bundle, tab 6, page 67,
Right.
that this is a question of fact.
So not a question of planning judgment.
Not a question of planning judgment.
Right.
There is appellate authority on that point, specifically on that point. So I don't think I need to trouble the court with that. I think what my learned friend was saying was that whether or not there's been a substantial change turns on the application of a Wednesbury test, and that comes originally from Wheatcroft and then subsequently Mr. Justice Singh, as he then was, judgment in wet finishing works. And what it says is that to the extent that you're looking as to whether there's been a change so substantial as to result in a completely different application, that requires a Wednesbury test, i.e. could any reasonable planning authority properly directed conclude that this was the same application. If they could not, then it's not substantially the same. If they could, they're entitled to conclude.
So your submission that this is not appealable relates to the a priori conclusion that whether or not there has been any alteration whatsoever.
Yeah.
And if there has been an alteration, that's when the Wednesbury
Precisely, my
principle
lord. Yeah.
applies to the decision as to whether or not it should
Yeah.
be permitted.
But just so that the court is aware, and we don't need to turn up, Tesco and Norfolk specifically concerned a drainage condition, and there were plans submitted with the application for the approval of reserve matters which those pipes, and that was not enough to be an application to discharge, and it certainly in my submission isn't going to be enough in this case, because the application form which the court was shown includes a clear statement that the conditions other than the reserve matters conditions for which discharge is sought are 8 and 22, and refers expressly to them and to them alone, and that is verified by a declaration as to its truth and accuracy. For your note, it's supplemental bundle tab 2, page 25. So that is the scope of the application as sworn by the applicant. And I say that's the end of ground 1, 2.
All right, well, shall we break there?
I'm grateful.
I'll say 2:05.
All rise in favour.